where the Supreme Court has upheld insolvency law in entirety. They have upheld the ban on promoters to bid under the bankruptcy law, and that's a big one, and I think would have a meaningful influence, as I would given to understand, on the whole SR Steel issue. Um, but we'll kind of get a quick reactions in to understand what the road looks like ahead, because a lot of cases will come under the bankruptcy law. It's been seen and touted as the most meaningful reform, the reform of high impact when it comes to seeing the transition in corporate India from being entirely unregulated when it comes to an exit clause when a business goes kaput, to having a structure that can help in the whole insolvency and bankruptcy process at a time when a business can't stand on its own or cannot continue to hold on its own. So that's something that would be of meaningful change, like I pointed out. The Supreme Court is also saying that founders can't bid under the bankruptcy process, and like I said, there's so many cases which are right now hanging in the middle with regards to this particular clause, where promoters are not willing to let go of their businesses. There's much to and fro with regards to negotiations on at what price do these businesses get sold. There's a bit of a prestige issue attached to selling off businesses that are family owned, and so I think the Supreme Court's clarification on that front will go a long way in adding speed to the process of resolution when it comes to some of these disputed accounts. And like I said, we'll get in more reactions, but the Supreme Court has upheld the bankruptcy law in its complete entirety, and has upheld also the ban on promoters to bid under the bankruptcy law.
Well, yes, it is certainly good that the Supreme Court has upheld the constitutional validity of the IBC, but I'm not so sure that upholding it in its entirety, including Section 29A, is a very wise thing, because Section 29A, which was brought in more, I think, to assuage political issues really about the promoters and anybody related to the promoters being able to buy back an NPA at a very low discounted price. It was far too all-encompassing. It virtually ruled out anybody who had even the remotest of relationships with the promoters, regardless of whether the promoters themselves were directly guilty of fraud or whether it was just because of circumstances, extraneous circumstances, that the account had become an NPA. Contrast this with what is happening in the US, where Sears, a company which is once upon a time, almost synonymous with, with discounted sales, and it was effectively the Walmart of those days, and even now employs more than 50,000 people. So Sears is going into liquidation, and the promoter, the erstwhile promoter, is being allowed to buy it back, maybe at a discounted price, provided the creditors are satisfied with the deal that he's offering. This is a so sensible and pragmatic, I think, way of approaching it, rather than to have the very all-encompassing nature of Section 29A. Yes, wherever the promoter was guilty of fraud, wherever the promoter has deliberately run the company to the ground, there would exclusions which are there presently under Section 29A. That, I think, needed a rethink. The simple reason that is going to do far more damage to the economy than the benefit in terms of ensuring speedy resolution of NPAs.